what is copyright? And I know this is a really experienced audience, so I'm not going to teach grandmothers to suck eggs, as the old English cliche goes. I'm going to skip through this fairly quickly. We've got about 45 minutes of presentation. I want to get to the practical stuff. So I think most people will know what copyright is under English law and other laws in Europe and around the world. It's really the same. It's an exclusive legal right given to a creator to protect their products or content. And the key is originality from being copied. So whether that's reproduction, adaptation, distribution, performance, without the creator's permission. And that's really a fairly straightforward idea in principle, but it does get very complicated because copyright is essentially a form of property, really very little difference to owning a house or any other type of tangible property. So copyright can be sold in the sense of assigned to another person. It can be vested when someone dies. It can be licensed, in the same way as a property can be rented out. You can rent out your copyright. And of course, it can be infringed. You can trespass onto someone's copyright effectively. You can take a part of it and use it as your own. You can damage it. You can destroy it. You can mutilate it, as it were. You can take a work of art and you can, cause some sort of adaptation or damage to it and change it. And the right of copyright prevents those sorts of action happening without the permission of the copyright holder. Okay, I think I'm going to try to, because I really have some problems with this machine, I'm going to try and, okay, see if we can, okay, it seems okay now. So does a copyright need to be registered? Under English law, a copyright work does not need any additional registration. Once the work has been created and it is an original work, it is automatically protected by copyright. There's no requirement to have it registered or even marked with any kind of copyright sign. In other jurisdictions, it is an option to register the copyright with a copyright office. And you can, by that means, create some more types of protection in the copyright work. One of the most useful things about any form of registration, and sometimes in England, what people do is they send a copy of the copyright work either to themselves or to their lawyer or to an agent with a postmark. And one of the reasons, of course, for doing that is to be able to show when the work was created, which would be part of the question if an issue of originality came up in a case. And that did come up in one case I was involved in, where we had to forensically open up an envelope, which the complainant in the case had sent to himself in order to prove when he had originally come up with an idea. It was actually a pitch for a television series, and he'd written it out with sketches and various forms of expression of the idea. And he posted it to himself, and he had a sealed envelope with a postmark. And we actually went through a very interesting piece of drama on expert evidence, where we had to get a forensic expert to use ultraviolet light to actually open up the envelope to prove that the envelope hadn't been tampered with during the period in which he had, from the time he claimed he had sent it to himself. So, yeah, I think the issue of originality can be very important and can actually lead to some significant areas of dispute. Okay, still slightly battling with my computer. I am sorry about that, but I'll battle on. Copyright subsists in the following works: original dramatic, musical, artistic works, published editions of what are called typographical arrangements. That's quite an old-fashioned expression. Literary copyright, films, broadcast sound recordings, And then we come to areas which are really important to us: news, facts, and information. So let's focus a little bit on that. How do you copyright news, facts, and information? Well, the form of copyright, it will arise when the information, the facts that you're presenting are expressed in a tangible medium. And of course, that would either be, in the case of a journalist, a news article, television broadcast, or indeed for a photojournalist, the creation of a photograph or film. So the important thing here is to go back to the concept of originality, of course. The news, the facts, and the information may be matters of common knowledge and common understanding, accessibility, already available to the public. But of course, what the journalist does is pull those together using their means of expressing themselves, their creativity, their artistry actually, to create an original work in a tangible medium. News, facts, information are generally ideas which you will have in your head, and the form of copyright protection comes into existence, the house is built when you reduce that copyright work into a tangible medium, some kind of permanent form as an article or, as we say, a film, photograph, etc. Okay. Duration of copyright. Under English law, a copyright lasts for 70 years from the end of the year in which the author of the work dies. So if I create a piece of copyright today, I have 70 years plus from the end of the year in which I pass away to own that copyright and, of course, be able to pass it on to my estate. So it is a significant duration for a literary, dramatic, musical, artistic work. Where the work is a film, like a film recording, a video, etc., then the copyright is shorter. It's 50 years. It's 50 years for films. And that's the same for sound recordings and broadcasts. So ownership of the rights, this is probably fairly obvious. The owner of the work is the first originator, the author of the work, that's the first owner of the work. Bear in mind, very importantly, that an employee who creates work in the course of employment is generally subject to the rule that the copyright will be owned by their employer. So an employee's work created during the course of employer is generally owned by the employer, but that is subject to any other agreements which may be made between the employer and the employee. So it may be that when you're negotiating your contract of employment, you actually say to your employer, and you're perfectly within your rights to do this as a journalist, okay, but what I create for my salary, I'm going to keep the copywriting. And that very often actually happens with some major journalists. Yeah, and of course, an employee means not just a contract of service, but also potentially an apprenticeship. And this may also arise in the case of contractors who commission, whose work is commissioned by the contracting party. So if you commission a work, there is some law under English law that says that the person commissioning the work will own the copyright in the work which is created as a result. But that's not entirely straightforward as a matter of English common law, and it's much better to make a clear contractual arrangement or agreement with the person who is engaging you, so that there's no ambiguity about that. It's better not to rely on what is under English law, the Copyright Designs and Patents Act, or the common law for these sorts of issues. It's actually much easier and will help the journalist down the line to have a clear contract, whether as a contractor, external contractor, or as an employee dealing with ownership of copyright. Okay, I think I'm going to try and jump over to the other machine. My only question is, how do we get that screen onto the No, we can't get that onto the master presentation, can we? Okay, so we'll battle on with this one, I'm afraid. All right. I'm just having some problem moving to the next slide. Okay. Right. Okay, hopefully that's going to work now. Okay, so then the next point is on assignment of copyright. So assignment is effectively how you sell or rent the house. And an assignment should be thought of as, in the same way as you assign a lease in land or in property, you can assign ownership of copyright. As the originator, you can't actually get rid of your right as the originator of the work permanently. You can only waive your claims, but ultimately in law, you are the originator of the material, and the law doesn't recognize the idea that you can sell off your originating role in the creation of the work, which is why we talk about assignments rather than a wholesale, transfer of ownership of copyright. We assign the rights under copyright, and it's effectively a contract. So when you transfer your copyright to someone else, really what you're doing is you're creating a contract which says, I'm not going to exercise my ownership rights in the material. I'm going to allow you to be able to exercise those rights effectively on my behalf. And I'm entering into a contract with you, an assignment of my rights to you. And that therefore can either, and it can effectively work like a sale because you can assign all your rights permanently to a third party, but you can also assign rights for a period. So an assignment of copyright doesn't have to be permanent. It could be for a number of years, and then it reverts back to you. And not too long ago, my colleague David Romain and I in London, David is on this presentation as well, were working for a publisher in Holland, dealing with a very famous author. I wouldn't say what type of author, but that author had passed away and had assigned rights to a major publisher. And we were dealing with some of the issues arising when the assignment effectively came to an end and the copyright went back to the estate of the author. And of course, one can imagine with some very popular works, these can be very valuable rights. So it may be that you don't want to assign the right permanently. You want to have it come back to yourself or to your estate in a number of years. So it's really important to think of assignment not as a permanent sale of your rights. There are ways in which you can have those rights come back to you and impose other conditions under contract. Quick couple of important points. Assignment is only legally binding if it's in writing and it's signed by or on behalf of the assigner. Then we move to licenses. All a license is a shorter form of assignment, and perhaps allowing fewer rights to be assigned for a shorter period. Basically, there are two types of license. There's an exclusive license, which enables the licensee to use the copyright in a manner specified by the license to the exclusion of all others, including the copyright owner. So I have an exclusive right to publish your story in my newspaper, and no one else can publish that story. And it may be that I have some other rights to sell on that story to other people, and I've paid a handsome reward for that exclusive license. Or as a journalist, I may offer a non-exclusive license. I may say, I'm going to give you the right to publish the story, but please note, I will also be able to market this story to other publishers. And my father is a freelance journalist who's worked both in Ghana and the UK, has come up with, some very, interviews of very high-profile individuals. I remember an individual who was running for president of Nigeria many years ago, Mr. Moshood Abiola, and he got an exclusive interview with him. Actually, he got an exclusive interview with Nelson Mandela at some point as well. But with Abiola, he sold that interview to a number of publishers around the world, including Time magazine, and I think The Guardian or The Observer, and possibly De Volkskrant in Holland as well. And so, that would have been an example for me, in my early years, seeing a non-exclusive license being marketed by a journalist. Okay, so, this is a quick recap, really. What are the rights that you have for either as the originator of the work, or if you hold a license, or well, this is really dealing with the originator of the work. You have a right to exclusive use of your work for the duration of copyright. You've got the right to exploit your copyright, and you have the right to receive attribution or acknowledgement for your work, what's quite often called moral rights. We think of copyright, and certainly I do, thinking back to my own father's experience in the traditional media context of print, newspapers or radio broadcast television, and some of the concepts of licensing that arise, syndication, for example, where copyright is held by one publication and they have an agreement to send their copyrighted material to other media. We think of those concepts as coming up in the traditional media context. And I think a lot of people will be familiar with those. But really where some of the new law is being developed and some of the really tricky challenges are arising is in relation to the new media space. So, online news articles are regularly abused far more readily than publications in print media ever used to in the past. It's just so easy to copy and paste or even just to hyperlink to an article and potentially create profit as a result of that. That similar issues arise with blogs. Somehow there is a feeling that online, if something is published in a blog or in a news article online, psychologically, copyright is much more laissez-faire and you can make use of it. There are these real problems arising for publishers, for journalists, and it's exacerbated, manyfold by concepts of social media, whether that's Facebook or Twitter, Instagram, etc. And in our practice, we come across so often originators of original material, whether that's music or photographs in particular, but also journalistic content, which is being misused regularly on social media. I think everyone's familiar with this problem. So just in a few minutes on this presentation, we will think through some of the ways to deal with these challenges. But there is some law developing in these areas. There is a recent case from the European Union Council of Justice called InfoPack, which has been applied in a number of jurisdictions around the world, which is a case concerning hyperlinks and the fact that actually you can have a case of infringement of copyright in making use of a mere hyperlink, if that hyperlink is sufficiently detailed as an original work to constitute a copyrightable material in itself. And a quick jump over to another concept when thinking about originality. A newspaper headline may and certainly can have copyright in itself. So we don't think of copyright as necessarily only applying to a full news article or a full work. It can apply to elements of the work as well. And this ruling, the InfoPack case about hyperlinks, is a good way of explaining the concept. It's not about form or quantity. The test for whether something has a quality which will attract copyright protection is about originality and is qualitative rather than quantitative. I hope that makes sense. And if anyone has any questions on that, it can be a complicated concept. But if, for example, a news story has a very catchy and original headline, That headline, as I say, may be a copyright work. The hyperlink, which may include that headline, could be a copyright work. And then the text of the article could constitute a work which can be copied as well, of course. Bear in mind, within that text, you may have some non-original material. So if an infringer took from your article a quote from a national president, which he had given in a press conference, and which was available to the world and maybe seen by many thousands of people, there may be an argument that that element of your work is not original and is not therefore subject to copyright protection. But other elements of the work, like the headline or your original introduction to the issue, your comment on the issue, your opinions, how you bring in other relevant information, how you've presented the material as a whole, will certainly be likely to have copyright protection, even if some elements do not. And so that concept works both ways. You know, a headline on its own may be copyrightable and protectable, but actually a large tranche of your text, which you would expect to be copyrightable, may not be because it's simply not original. Okay, I'll talk about infringement quite quickly, just because of time. I think, you know, it's fairly obvious that if you copy or reproduce a work, that's going to be an infringement. Another two ways in which infringements can occur is through publication, i.e. thinking about, you know, how copies may be printed and issued to the public, but also communicating to the public. So copyright is a very old-fashioned law, and it's stuck in the language of reproducing physical materials, issuing of copies to the public. But in recent years, the law of copyright around the world has embraced the concept of communication through intangible media, such as broadcasting as well. So it is most certainly possible to infringe copyright by broadcasting or otherwise communicating it to the public. Okay, so I'm now going to go into some of the issues that may arise when focusing on media professionals, and some of the restrictions, first of all. Not to copy another copyright holder's work without permission, always acknowledging the source of the work if it is not your original content. And then I think most importantly for journalists is thinking about how the principles of fair dealing, or under US law, fair use, and possibly in Europe, the concept is fair use of copyright work. So fair dealing under English law is a defense to a claim for breach of copyright. So if you have used someone else's copyright work, the defense of fair dealing will allow you to be able to continue using it and to, you know, get you out of a legal dispute without having to pay damages, etc. Notwithstanding, you don't have permission, you haven't paid royalties, or vice versa. So what does fair dealing mean under English law? And I think it's fair to say this is one concept of copyright that does vary from jurisdiction to jurisdiction. But these basic concepts are hopefully quite familiar and are to be found in other copyright laws around the world. And again, if anyone has any perspectives from another jurisdiction they want to share in the Q&A, feel free to do so. So there are three basic forms of fair dealing under English law, where you're criticizing or reviewing a work. So if you were to take a work of art or a film, and you were to, let's take maybe a film, and you're a film critic journalist. I remember old Barry Norman had a program in the UK on Channel 4, which was very popular. And there'd be some substantial clips of the movies which he was reviewing. And then that's entirely fair. That's a form of fair dealing, to make use of the work for the purposes of criticism or review. Naturally, if you are quoting someone else's work in your own work, provided you attribute it, that will be permissible as fair dealing. And of course, reporting current events. So if you're reporting an ongoing news story in your media organization, you're entitled to make use of someone else's copyright material. Criticism or review, hopefully this is fairly obvious. You can make use of the work, as I say, without infringing for the purpose of criticism or review. The important point is the middle bullet. You must not be more than, you must not use more than is necessary to fulfill the purpose of the proposed publication or work. So a clip from a film, rather than showing the whole film or the whole of, the best scene of the film, would be permissible. And of course, as I say, you must make sure that the work is accompanied by an acknowledgement. And with quotations, it's worth bearing in mind, they must have been made available to the public. So if a journalist has got an exclusive interview with a world leader or whatever it might be, they've got that on their recording device and it hasn't been issued to the public, you can't say, well, I'm just coming under the quotations fair dealing by making use of that, because it hasn't yet been issued to the public. And again, just to emphasize this point, you will get protection even on quotations, provided you use not more than is required for the specific purpose for which you're using the work. So, if your news story is about the fact that the world leader has outlined maybe a brand new plan for dealing with COVID in his country or her country, you might want to quote that section of the interview, but there may be a whole load of other material which was in the interview which isn't relevant to that, which, so to then publish the full transcript would likely be an infringement of the copyright of the person who conducted the interview. And as I say, it must be accompanied by sufficient acknowledgement. So photographs are excluded. It's important to flag for reporting current events. And again, the key thing is acknowledgement. So photojournalists are protected when it comes to reporting current events. And the real issue with fair dealing is to think about what might amount to substantially taking someone else's work. If there's a natural disaster or an oil spillage, and you've got some footage of the cleanup, or there's some text that you need to use for that. Again, it's about not using what would be beyond what is necessary to convey to your audience the information you need to convey. And I like the concept of proportionality, which is in European law when thinking about balancing rights. So if you're going to infringe a copyright of someone else, then think about what is proportionate for the purposes of your use of the material. Think about what would be not more than is necessary to convey what you need to convey. Okay, so that's a really quick run through. I think I've got about 15 minutes left. Thanks, Victoria, who's keeping me on time. So that's a really quick run through some of the more theoretical aspects of the law of copyright. I'm going to spend a little bit of time now just thinking about some of the practical issues that can arise. And we've picked up 5 broad areas. Actually, third-party copyright we'll throw in with some of the other ideas. But let's look first of all at syndication, then we'll look at some of the issues arising on pitching ideas to media organizations. We'll also look at the issue of copyright versus confidentiality and the relevance of non-disclosure agreements. And then we'll look at photographs as well. And we only have a little time, so we can really just do a bit of a taster on these. And hopefully with the one-to-one sessions or with the Q&A, we can go into some of these areas in more detail. So first of all, syndication. What is syndication? Actually, I first came across this concept when I worked in-house at the Guardian newspaper, and I had to look at some of the syndication deals and agreements. I don't want to disclose anything from that particular newspaper, but in general, a syndication agreement may be where one media house has a stable of journalists producing copyrighted material, and they have an agreement with quite often an overseas, but not always overseas, agency or publisher or media organization where they share material with each other. So the graphic newspaper in Ghana, for example, may share their material with the Guardian newspaper in Nigeria or the Mail and Guardian in South Africa. And the equivalent may happen with, the UK Guardian and, I don't know, the Sydney Morning Herald, for example. And those two newspapers have an agreement to share their copyright material, which basically means that if you as a freelance journalist sell in your article to the Guardian, they might pay you, I don't know, £400, £1,000, maybe more, because you're such a fantastic journalist. But you then don't be surprised if you then see your article not only on the Guardian website, but also on, for example, the Sydney Morning Herald website as well. Now, how does that work in a legal setting? You as the freelancer may pick up the phone to your editor and talk through the story. You write the story, you send it to the editor, it gets published, you get paid. Very often, that's the contractual framework you're working in, and there's no written agreement. And for most experienced professional journalists, they will have an understanding, frankly, in my view, not always a very comprehensive understanding, and media organizations exploit journalists in this regard, but you'll have an understanding that your work will go out on the Guardian platform of publications, and oh well, it went to the Sydney Morning Herald, it was credited to the Guardian, I was given the byline, so I don't have a problem. But you are entitled to say, hang on a minute, what is the actual content of your syndication deal, Mr. Publishing Newspaper? I would like to know where you're going to put my material, because I might be negotiating separately with the Sydney Morning Herald, and I'd like to do my own deal with them. So unless the newspaper, I mean, this is where the concept of assignment becomes so important, unless the newspaper has expressly agreed with you in your assignment of your copyrights, that you will allow them to market that right in other jurisdictions with other publishers, they don't have permission to do so. So it's worth thinking about that. Now, very often, a young journalist or a journalist who comes across a big media house who's interested in them will have very, very little bargaining power, and one has to be alive to that practicality. Nevertheless, it is worth, when you do have negotiating power, thinking through this issue and saying, well, I want to know more about how you syndicate my material, because you may want to either raise your price on that basis, especially if they're getting paid for the material they syndicate, or you may want to impose some restrictions. And that's a matter of negotiation, and I don't think it's necessary to be shy about that. Yep, so I think that really deals with syndication. I want to run through these points fairly quickly. Bear in mind, if you use an agent, they can take a split of the fee, and if that's a news agency, it can be actually up to 50%. Bear in mind, again, you may be given a contract. It may be a very long and complicated contract, and then there may be some small print in there dealing with things like syndication, which you haven't necessarily agreed. So as I say, it is worth looking at what the contractual framework is. It's not satisfactory for a freelancer to regularly be giving copy to a publisher and there's no written agreement at all. That creates ambiguity, it creates risk, the possibility of dispute in future. And I think all of these things, certainly as you become experienced as experienced journalists, are things that you can do yourself. You don't need to get lawyers involved and have hugely complicated contracts to deal with things like licensing and syndication. But if you do, just take care of some of these issues and maybe get advice to get a template agreement in place. Okay, so the next point is on pitching ideas to media. And I think I mentioned some of my father's moanings at me about this, and I do have a huge amount of sympathy with freelancers who have to regularly pitch ideas to editors, often very, very quickly, and with very little evidence to be able to hold up and say, well, I gave you that story first and you used it without paying me. So it becomes a really challenging issue. And the law doesn't help, because when you pitch an idea, hey, there is a civil unrest issue brewing now in Nigeria. Actually, this is true, where people are protesting against police brutality. That's a story which is now a few days old, but maybe someone had that information, pitches it to an editor. That pitch has no protection really, because this is a factual event taking place. The event is not confidential, and you're simply communicating that information to an editor in a context where there's no reduction to a tangible form to create copyright. Now, maybe if you sent an email with the idea quite sufficiently detailed, you might then begin to create some kind of copyright protection. But unless that email is reproduced, it's still only an idea. And so very often journalists get exploited when pitching ideas, because there is no copyright in an idea. Until it's reduced to tangible, permanent form as an original work, you're not going to have copyright in it. Now, we'll come on to thinking about confidentiality. And it may be that you can create a framework in which, when you pitch ideas, your editor is thinking, this is an exclusive pitch to me, I need to treat it with respect. And you can use a non-disclosure agreement, a confidentiality agreement, for certain purposes to assist you. But the problem will still be that the basic information you're conveying, unless it's not news and factual and current events, but maybe relates to something else, perhaps like an exclusive review of a new restaurant, very often there will not be originality in the material, or there may not be confidentiality in the material. So you do need to think very, very carefully about how you do this. And the key is to offer a teaser, to my mind anyways, to offer a teaser or a taster rather than the full story or the full information. Don't let the editor know what the punchline is until they see your full article. And you can, I think, with experience, find a way to convey a synopsis or a teaser or a taster without giving the absolute gold dust that you've got. I mean, I've had scenarios where an editor, not, no sort of personal family experience here, but where an editor has said, oh, that sounds very interesting. So who's the person you're interviewing? Oh, yes, okay. And what's their phone number? Right, okay, got it. Yep, okay, I've got that information. I'll get back to you if we're interested. They then call up the person who is offered the exclusive interview, use some misrepresentation, and do the exclusive interview themselves. It can be as bad as that. But maybe the phone number is confidential information. Maybe the package of the identity of the person, what they're telling you, their contact details, and a few other nuggets are all information you can actually protect under confidentiality. So, it's not straightforward, but there are things you can do to protect yourself when pitching an idea. And hopefully we'll have more time to go into this during these sessions. So as I say, you can use an NDA. I think if you're doing more than just a quick phone call, pitching ideas to an editor you know very well, that's where you may want to get into using an NDA. If it's a new publisher you're dealing with, a new editor, you're coming to them with a substantial story. It might be a book treatment. It could be an idea for a film or a documentary. Absolutely. In those sort of more detailed scenarios, a non-disclosure agreement, an NDA, could be extremely useful when pitching your ideas. I think there is a counterpoint here, which is that if you go to, and this is from experience of seeing these situations go wrong, if as a journalist you go into an editor with an army of legal material, which you expect them to sign before that you're willing to share your idea, you may of course put them off. And I've had scenarios where I've been in-house at a publisher, and the editor comes in scratching their head saying, oh gosh, I've got this new journalist, I'm quite interested in what they want to offer, but they've given me this huge legal headache, and I really don't have time to deal with that. So one has to be very careful how you go about not only pitching your idea, but you also go about pitching your protection of legal rights. And if that is overdone, or it's presented in a way which doesn't sit easily with an editor who may have a familiar way of dealing with these issues, if you don't use sort of right diplomacy or salesman's techniques, it could put them off. So it's important to take some care with that. But it's certainly possible to do some preparation and have a very, very simple, easy to understand, maybe even a one-page, plain speaking, non-disclosure agreement drafted. And you send that through perhaps right at the beginning of the relationship, and hopefully they sign it. Frankly, even if they don't sign it, under English law, they're on notice that you're protecting your work as confidential as well as under copyright. That's really the value of a non-disclosure agreement. You're putting the publisher on notice that you're going to be communicating material to them within a framework of confidentiality. Quickly on photographs, I think photographs create some really unusual and specific problems. Of course, the creator of the image is usually the copyright owner, unless there is a contrary agreement, such as commissioning, or in the course of the employment, as we've said. These may arise as situations where the photographer isn't the owner of the image. But I assume that you're going to need the permission of a photographer if you didn't take the photograph yourself. I think that's a really good starting point. And I think, of course you can, there are whole photo editor departments and, rights dealers in major publishing organizations who do this as a matter of course. But if you're self-publishing or you have to deal with this issue, it's really important to get it right. And, it's about getting in touch with the copyright holder. I love Google image search, which I've found to be an incredibly valuable tool. You see an image online, you want to use it. You can nowadays do a Google image search and you'll begin to find data on the particular image. Look at the metadata of digital files. So every digital file has key information within the background data held on that image. And quite often that will include information that can help you identify the copyright holder. Most professional, experienced photographers do not put their photographs into public without using a watermark or some kind of pixelation feature to make sure that the work is either identifiable as theirs or not usable in that form if someone wants to reproduce it professionally. And that's the real beauty of using a watermark on your images. So, of course, if the copyright has expired, you may be able to use the image. And if the image is held under one of these rights holding databases like Creative Commons, then you may be able to use the image as well. So it's not every photograph which is, you need permission to use. And as I say, watermarking or pixelating photos yourself, your own photos, identifying yourself in the metadata, and introducing terms of use on your blog or website. Thank you to my colleague Victoria for that idea. Is a really, really good way of protecting your copyright. A photographer may not need to put all their terms and conditions on every photograph they put into public, but if you know it's that photographer, perhaps there's a URL or a watermark, you search under that watermark and you will come to the photographer's web page, which will show their terms of use and contact details for how to get permission to use their photograph. And of course, if someone's used your photograph without permission, please, you're within your rights to contact the infringer. And I think that these points apply really to any kind of infringement. You can complain to the website operator. Sometimes the person, the blog, the news publisher website is a different entity from the website operator or even the internet service provider or the host of the site. You can not only contact and complain to the person who's infringed your rights, but very likely they will, you will have a right to go against the website operator or the ISP. At the very least, even if you can't sue them for breach of copyright, they may remove that site for infringing their own terms of use. And that can be a very effective strategy for dealing with some of these rogue online publishers. And again, you can have a template takedown notice, a cease and desist that you can send to anyone who infringes your copyright. to make sure that they behave properly next time, or even to go further and claim compensation, etc. So those are some very quick points on some specific areas. We've only got just under 5 minutes left, so I'll just wrap up for now, and then I think we have a Q&A session. So some of the key takeaways from today's presentation. Copyright is a piece of property. You wouldn't go onto someone else's property without their permission, and really your copyright, other people's copyright should be treated the same way, unless you have one of the fair dealing exceptions or you have their permission. You can't deal with someone else's copyright, and really it's worth thinking of it as trespassing on someone's land, because frankly, as a legal concept, it's very little different. As I've said, photojournalists should watermark their images. I think this is a slightly over blunt statement, my third point. Avoid reproducing content generated by another person, well, without their permission. Think of it as copyrightable material, and think about how you can make use of it without either seeking their permission under the fair dealing exceptions, or get in touch with them and get permission. Ensure there's clear understanding of ownership when you're working for an organization, and keep an eye online of use being made of your work. It regularly occurs. I've written a few editions of a book on defamation, and sometimes that book gets reproduced. Chapters of it find their way into people's academic works, etc. And you may or may not want to take some action over that, or at the very least get acknowledged and given credit. And I think that of course works two ways: give credit and acknowledgements as well where it's due. We could talk about this subject all day, but actually we're going to be talking about copyright, I think, over the next 2 days, which is wonderful. I think there are going to be these one-on-one sessions, and hopefully this has given an opportunity to spark some of those discussions and go into some further areas. And I believe we now have, is it 15 minutes of Q&A? So I'll hand back to Anna to host that session. Thank you.
Thank you, Kyrie, for this amazing presentation. We learned a lot about copyrights. So thank you very much.
Sorry about the technical glitches, by the way.
But it is very important, because we were mentioning last time that sometimes just the fact that we are using this terminology is going to help us to feel empowered and to have a more balanced relationship when we have negotiations with our publishers. So it is really good to have this kind of knowledge. And as you said, we have now our Q&A. We had a lot of questions in the chat box, which is really great. Some of them were already answered, but we can go through the other questions. Estela, thank you very much.
Yes, so as Anna Maria already said, I think some of the questions you already answered throughout the presentation, for example, about a non-disclosure agreement, what it is, how it works. There were a lot of questions about pitching to different media and what happens if all of those media accept your pitch.
Yes.
But I think that was also answered already, and maybe also again the note that there will be the mentorship sessions if you have a specific question to your case. Another question from Isabel was that how about blog posts and Instagram posts? Does the author already have copyright?
Brilliant. I'm making a note of these. Thank you.
Corrie, do you want to keep notes of the questions or answer one by one?
Yeah, maybe I can take these two. And then I don't know how many questions there are altogether, but I can deal with these, and then we can take them in groups of 2 or 3. Shall we do that?
Yeah. Sounds good.
Okay. So very good question. You've made a pitch. Excellent question. And your pitch gets accepted by a whole bunch of media organizations. How do you deal with that? And I think my father has been in precisely that position, and sometimes it can get quite awkward. My advice would be to have a template pitch wording. It doesn't have to be anything complicated, but I think the key is to be as transparent as you can be, and ideally to let the media organization know that this is being pitched to a number of other organizations. You may want to go further and say the terms on which you will be able to use my story will be a non-exclusive license. So this story will appear in other publications, and quite often the media organization will want to know which other publications it might be used in. So of course, if it's that situation of, the Guardian and the Sydney Morning Herald, and they have that syndication agreement already, then that will take some preparation, so that perhaps they need to have a specific agreement with their syndication partner that this particular publication falls outside of the syndication agreement. Or they may say to you, well, no, you can't pitch to them because we've already got a syndication agreement with them. You're wasting your time. And actually, that may be the right answer. You say, oh, right, okay, fine. I won't pitch to that publication as well. I'll just pitch to you and someone else who's completely independent. So I think being transparent, thinking ahead to this type of issue, and maybe having some pitch wording, doesn't have to be a full license agreement, but letting them know what your basic terms will be is extremely useful, and actually shows you to be very professional as well. So that's, I think, how I would deal with that. Then the next question was on things like blog posts and Instagram. How does copyright work in these social media platforms? And again, excellent question. The starting point is the terms of use of the platform itself. Well, you could say the starting point is what you've written has your copyright. So you're the copyright owner in that material. But bear in mind that by signing up to Instagram or, sort of whatever it might be, Wordsmith, blogs, or some other sort of platform that publishes, you will be contractually bound by their terms of use. And those terms of use will very often include copyright wording. And they may say, as far as anything you produce, which is your original copyright content, is subject to an automatic license, not only to us, but to all our users as well. And those licenses can be very, very broad and can lead to abuse. So you have to be very careful at looking, if you are a professional using a social media platform, look very, very carefully at the terms of use and make sure you're happy with those terms when putting your material there. It's getting to be a real problem, as I said before. The number of times, frankly, on a weekly basis that journalists complain to me about misuse of social media or want to use social media content themselves is extraordinary. So, almost on every editorial desk will be an editor and a lawyer scratching their heads about the fact that there is a really fantastic picture of the person they're publishing a story about on their social media channel. And bear in mind, that may not only lead to issues of copyright, but may lead to issues of privacy as well. Because if you make use of an image on a social media site and you haven't really understood what the permissions are, you may end up infringing someone else's right to personal privacy. So again, this works both ways, but ultimately the starting point is, of course, as the author, you're a copyright holder. And secondly, check out what those terms of use are, because once you sign up, you've entered into a contract over those terms of use. Thank you.
That's a great answer. Yeah, I think it's very tricky once you enter like a social platform where you have different laws or like terms of use. Oh God. So the next set of questions, on the one hand, we have like country-specific copyrights. Lucia is asking, she lives in Italy, but she publishes most in Germany, Austria, Switzerland, and is not sure what copyright applies. And actually a very similar question from Romina, which who asks about different copyright laws, and if the author is based in one country, does this copyright law apply, or is it the copyright law where they work? So this bit of like cross-border.
Excellent point. Yes. Okay, shall I deal with that one as best I can?
Mm-hmm.
Okay, before we move on, that's a really tricky area, and I'll hold my hand up and say, you know, I'm not a European lawyer, and I can't advise on those specific jurisdictions. But the issue that comes up is one of cross-border copyright issues and conflict of laws. So let's start with this as a basic concept in the law of copyright. Again, it's a bit like property. Where is the original work created? Because that question will inform on which copyright law applies in the first place to the work. So if I sit in England and I create a work, the starting point will be that that work is subject to the English Copyright Designs and Patents Act 1988 and that regime of copyright. If you sit in Italy and create a work, it's most likely that Italian law will apply. Now, we also know that European law has, of course, been harmonized in a lot of areas, I believe also in relation to copyright, so that there are some common standards. And I think one thing that would be very useful for us to have as a resource will be a reference to an overview of the various, of the copyright regime under European law. And that's something that Victoria and I will try and dig up in the course of today and tomorrow to share with everyone. So assuming the copyright is created in your country of origin, you then start dealing with that work in another country and there are alternative copyright laws that apply. Again, it's going to come down to your contractual terms of dealing in that country. So if I, as an Italian, have created an article and I want to sell it into a German publication, it may be that I will say, look, here are my license terms, and I'm more comfortable with Italian law for my license. My license is a contractual agreement, and within that contract, I can specify that Italian law will apply to my license. And if I want to be really firm with the publisher about that and say, either you sign up to my contract under Italian law or we don't do a deal, that's fine, that's your prerogative. Alternatively, the publisher in Germany might say, we have a standard license agreement for all our contributors, you will sign up to it and it's under German law. And again, you will have that choice whether you accept that or not, or you may wish to negotiate with them. And very often lawyers can be involved in amending these contracts, and it's perfectly permissible to amend the choice of law in the agreement to specify either German or Italian or English or any other law that you want. So there's a basic level to this question, which is where's the property created and what law applies? But as you go down into licensing and assignment, you can apply different laws. And actually a copyright created in Italy can be the subject of an assignment under English law or German law or French law. So the fact that the owner, the original copyright was under one law doesn't mean you can't sell it under another law. The same with actually with a house. You can sell a house in another country. So long as it, under the original country's law, what you've done is permissible for their purposes. So under English law, the assignment must be in writing, but that doesn't mean that the assignment can't be subject to German law. Let's not continue down this road. We'll talk forever on this. It's interesting for lawyers, but maybe not anyone else. But hopefully that answers that question.
That's a very good point. Anna Maria, how much time do we have left? I think we have 3 questions.
I think we can answer them. Yeah, I think we have around 6 minutes. Yeah.
Okay. So then I will ask them in a group again. The first one is on Creative Commons. Jonathan is asking if the content is originally published under Creative Commons license, can another form of copyright be asserted later?
Excellent question.
And then the next one is on music by Stephen Quinn. And he's asking about, very specifically, is using 15 seconds of a 2-minute 27 duration piece of music acceptable? Probably it's about using music in general, how it works.
I'm going to ask a follow-up to the second one. So 15 seconds, can you use 15 seconds of a 2-minute piece of music? Mm-hmm. For what purposes? Is it for a review? Or are you thinking of using it in a commercial setting, like in an advertisement or in your own piece of music? So what the context is very important there. Maybe he can put in the comments an answer to that supplementary point.
That would be great, Stephen, if you're could write that in the chat. In a short film, he says.
In a short film?
Mm-hmm.
Very interesting. Okay, thank you. Is that all?
The last question is from Isabel, and she asked, if I write an article for a publication without a contract, who owns the rights?
Excellent. Thank you so much. That's 3 fabulous questions. Gosh. So the first one is about Creative Commons. So a piece of work is originally published under Creative Commons. Can you exercise another form of copyright protection later on? So as I mentioned in the presentation, Creative Commons is a platform where material is given to the platform effectively for anyone to use, but it still contains certain conditions of the use. And let's broaden it not just to specifically Creative Commons, but any platform which has a database of copyrighted materials, but which are free for the public to use. If you've submitted your work to that platform, you haven't revoked all your rights. Do you remember when I said at the beginning, no one can take away from you the fact that you're the owner of a copyright? You can actually sign away those rights, and then actually, yes, arguably that the contract will make it impossible for you to claim the rights back. But in most cases, you can revoke the rights that you've signed away. So look very carefully at the terms of use of the site, whether it's Creative Commons or another similar platform, and see what your means of revocation of the license are, because effectively you've given a license, and you've given a license for free use of your work, but you can revoke that license. Even an assignment in certain circumstances can be revoked, in the same way as if you sell a house, but there was a fraud in the sale, the court can cancel the sale and give you back the house. It's the same sort of concept. It may be difficult because you may sign away rights fully with your eyes open and permanently. And then you'd have to have a new agreement to get the rights back. You may even have to buy them back in certain circumstances. But I think with Creative Commons, it should be straightforward to say to the platform, I am revoking or I'm removing that work from your platform and revoking any such licenses. That may not allow you to deal with the fact that someone may already have used the work, but it will hopefully be able to assist you going forward. You can control copyright in the work again. Second question, the piece of music is 15 seconds to be used in a short film, 15 seconds of music to be used in a 2-minute piece in a short film, unless that film falls into the category of, reporting current events, and it's relevant to report the current events. So the current events would really have to be about the music, or it's a criticism or review, i.e. you're reviewing the piece of music. We talked about film clips earlier. You may if it's a purely creative piece of film, then you're going to need permission. And the fact that it's 15 seconds, maybe it's 15 seconds of a 6-minute musical arrangement. But remember, we said copyright isn't about quantity, it's about quality. So if you took the chorus or the best bit of a song, I'm thinking of John Coltrane now for some reason, and you took his best bit of saxophone in a very, very long treatment, and that was your 15 seconds, you may be infringing that copyright. Not with John Coltrane, because the copyright would only have lasted 50 years or whatever it is, so in that recording. So I think the answer is take care with that, because there could be an infringement there unless you're reporting current events or you're reviewing or criticizing the work in question. And then the final one was where you submit or you pitch you've submitted an article for publication without a contract. Who gets the rights? Again, there's some other questions that may arise, like, has the work been commissioned? Have you submitted the article as an employee? or are you a freelancer submitting to a fresh publication? If you are a freelancer and you submit to an editor with no contract, you have the copyright. If the editor wants to use your article, they have to enter into some kind of agreement with you to compensate you for using the article. But very often, editors of unethical publications take the view that if someone submits an article to them and doesn't claim any compensation when they do so, they're doing so for free and they can just publish it. And they abuse that power that they have over freelance journalists. So always, as I say, set out your terms in very brief text. You can be in an email: dear editor, I wish to submit this piece for you. My terms are as follows. I will be giving you a non-exclusive license. If you wish to use the work, I would demand a fee of $400. Here are my standard terms and conditions in an attached license agreement. Please let me know if you have any comments. I trust you'll confirm whether you wish to use the piece or not, and acknowledge this email, etc. Once you've done that, they can't use your work without your permission, frankly. If all you do is submit the article to them with nothing else, you may create an ambiguous situation for yourself. It might be more difficult to deal with if you don't have that standard wording that goes along with your pitch. I hope that answers those three fantastic questions. Wow, really excellent questions. So thank you for those. And yeah, look forward to answering more as we go through the individual sessions.
Cory, I hope we have time for one last question, because I saw that it's very important for the community. And yeah, it happens all the time. So we have a question from Alice. She works for a magazine that is owned by a huge media group in medians in different countries. She works for them as a freelancer, and very often they use the work done for the magazine in France and republish in other French magazines or other magazines around the world. They pay her something like 0.02% of the normal rate, and on top of that, they say that you won't be paid more than 600 euros a year for the work we publish it. And the question is there anything freelancers can do against this type of contracts?
Excellent, excellent question. And this is the core of it. This is bargaining power and how you negotiate better terms for yourself. And it's a huge problem. Now, this is a major media organization, and they will say, by publishing your work, we're creating a platform for you, which is a huge audience which you wouldn't otherwise have. And that's very often how journalists are exploited. And I mean, my experience, and others will have different views on this, but my experience is that your commodity is in your byline and your marketability as a journalist. And if you are creating really fantastic content for this media organization, and they tell you those are the standard terms, you can break those standard terms, because we all know there are journalists earning millions every year as columnists for national newspapers, for major media organizations. They do not stick to this 0.02%. They have different terms. And journalists earn thousands for the columns they write every week. Boris Johnson used to earn an absolute fortune. It's a matter of record when he was contributing to the Telegraph and to the New Statesman and other publications. So we may not all be Boris Johnson or hugely journalists with such huge clout, but you can still negotiate. The other really interesting possibility here is when journalists come together, whether as a union or as a collection of journalists, or possibly using collective societies, which in some countries are becoming more and more relevant. For example, in Ghana, where there's a terrible situation of abusing journalists, the Copyright Office, which runs the major collection agency in Ghana, is trying to think through whether they can protect freelance journalists and create a different percentage, a different tariff for freelance journalists dealing with major news organizations. And I think other countries may have similar schemes of collection societies, unions, or coming together, you know, maybe there are 10 of you in a similar situation for this publication, and you go together to negotiate. And that can be very effective with an editor or with a publication, which is saying to you, here are our standard terms, take it or leave it. That's what everyone else is subject to. Well, no, it's not, because I've come with everyone else and we're not happy. And then you negotiate, because, you know, it's a negotiation, and that has to be a two-way agreement. So even though they tell you the terms are standard, it's still a contract which you can negotiate. I must say, though, that, you know, those are fairly standard terms. Bog standard terms for freelancers tend to be these sort of numbers. But, you know, as I say, there is room for negotiation depending on the particular facts in the country where you are.